Hi, everybody. This is Dick and Sharon with the LA Progressive, back again with Bill Blum, our friend and frequent contributor, former judge, lawyer, so forth, who recently published an article comparing the Supreme Court decisions in South Carolina and Alabama and how they differ on voting rights. How you doing, Bill?
I'm doing really well. How are you?
Good.
Yeah, so Bill, we wanted to talk to you about these cases. Obviously, we have tremendous amount of respect for you and your legal knowledge, but also what I appreciate about your knowledge is that you can take very complex matters and simplify them for the average person who hasn't gone to law school, or maybe doesn't appreciate the finer, more nuanced ways that the courts will look at two different cases. And I like the way that you presented this Alexander v. South Carolina State Conference versus Allen v. Mulligan, and the two different ways that the court is addressing them and the potentially two different outcomes. So if you would share that with us.
Sure. So the Alabama case was handed down last term, and it was widely hailed as a surprise and major victory for voting rights activists. And that case involved Alabama's 2020-2021 congressional map. And the Supreme Court ordered Alabama to redo the map with the aim of giving Black residents, Black voters in Alabama, a second majority congressional district. Given the overall size of the Black population in Alabama, the Alabama map was held to violate Section 2 of the Voting Rights Act, and the Supreme Court also turned away a constitutional challenge raised by Alabama to the way that Section 2 was applied to their voting map. So that was a big victory for voting rights, but it was a 5-4 decision, and it was written by John Roberts, who's generally no friend of voting rights. And there was a concurrence written by Brett Kavanaugh, Justice Kavanaugh, who provided the deciding vote. And in his concurrence, he cautioned that these race-based remedies under the Voting Rights Act we shouldn't be extending them indefinitely into the future. And Roberts had similar language in his majority opinion, and it sounded very similar to the court's treatment of affirmative action, where the court's saying, maybe at one time affirmative action was necessary, but we no longer have a racist society, so let's move on. Roberts had the same reasoning in Shelby County, where he decimated two other provisions of the Voting Rights Act in 2013. So now along comes this case from South Carolina, the Alexander case, and people are wondering, well, the Supreme Court just, finished with the Alabama situation in Milligan. How does South Carolina differ? Well, South Carolina differs in very important respects. First of all, the South Carolina case is not a Voting Rights Act case. The plaintiffs in that case did not raise the Voting Rights Act in their complaint. What they did was they based their complaint exclusively under the 14th and 15th Amendments. So these are exclusively constitutional claims. And they cited 3 congressional districts in South Carolina. Like Alabama, South Carolina has 7 congressional districts, 7 seats, and currently only 1 held by a Democrat. So in the Alexander case, the case goes to a 3-judge panel, a 3-judge district court panel. They got a pretty liberal panel. And the court turned away 2 of the 3 challenges to the 2nd and 5th congressional districts in South Carolina, but upheld the complaint as to the 1st congressional district, which includes the city and county of Charleston. And that's the seat currently held by Nancy Mace. And the court held that that's a racial gerrymander. So South Carolina now has appealed that. And the law on racial gerrymandering is that it's unconstitutional to racially gerrymander your districts. That is to primarily and purposely either spread minority voters around a state or to pack them into one district to dilute their voting power. So the way that South Carolina tries to get around this is by saying, of course, we moved 30,000 Black residents, Black voters out of this district, but we didn't do it for racial reasons. We did it for political reasons because they're Democrats. And that's okay under the Constitution. And why is that okay under the Constitution? Because in 2019, again, an opinion authored by John Roberts, the Rucho versus Common Cause case out of North Carolina, the court held that partisan gerrymandering or political gerrymandering is not subject to the jurisdiction of the federal courts. So this is a pretty good case for racial gerrymandering legislatures to hide behind partisan politics. There is a case from 2017 in the Supreme Court, Cooper versus Harris, which says that you can't use race as a proxy for politics, but we'll see. We'll see what the Supreme Court says. The case is going to be argued October 11. I'm really not all that confident that the Supreme Court's going to affirm the lower court, because unlike Alabama, this isn't a case where the plaintiffs are saying we should get an additional district in which Black voters held a majority, but we should get enough Black residents in our voting district, in the 1st congressional district, so that the district is really a toss-up district. Because the way the map is drawn now, it's really strongly a Republican district to keep Representative Mace in power.
So this is potentially a devastating move. I mean, if it went forward that states could gerrymander according to politics, they say, when really it was racially based, every state would follow suit that wanted to do that kind of thing. It would be devastating.
Absolutely. Every racial gerrymander, as far as I can tell, is also political.
Yes. Right. And so the point here is that what we're looking at when we look at Alabama versus South Carolina is we're taking a look at institutional racism. On the one case, in the case of Alabama, it was specifically stated that this case is being brought because a Black population was being disadvantaged. And that was clearly stated, and that's why the court had to rule on whether or not Blacks were being disadvantaged because of the way that the new congressional lines were drawn. But in the second case, they don't bring up race. They're only talking about politics. And that is precisely what institutional racism does.
That's exactly right.
It removes the language of race. And in front of that, it puts some other reason. But we know that race is what is used to make the determination to disadvantage people.
That's exactly right. Now, since 2007, John Roberts has been saying, and this is a phrase you'll see repeated, the way to end racism is to stop talking about racism.
Mm-hmm. Yes.
He said that first in a busing case and imported it into the voting rights litigation and jurisprudence. And so this is the sleight of hand that he's engaged in the past. Maybe he will still uphold the 3-judge panel ruling, but if he does, I believe that it's because the Supreme Court is suffering this legitimacy crisis, and they're really being shamed and called on the carpet by activists who are pointing out that they are really politicians in Black robes.
That's right. They certainly seem to be, based on this. Well, thank you so much for that explanation, and we'll look and see how, when do we think this case is going to be heard?
October. This case will be heard October 11, and the state of South Carolina has asked the court for a decision by January because it has to redraw the voting map. The decision of the 3-judge panel hasn't been stayed, but the remedy can't be implemented while the case is before the Supreme Court. So the state wants a quick decision, and maybe we'll get a quick decision. If they don't, I don't know what South Carolina is really going to do with the upcoming election. Maybe they can act very quickly. The decision has to be in by the end of June.
Wow.
So you wonder what planet John Roberts and his colleagues live on when they think racism can be solved by not talking about it. Is that what we should have done with COVID? Just let people drop and not talk about it?
Well, the Supreme Court doesn't live in the same world that the rest of us live in. These are people with lifetime tenure and unlimited power, but that's for another day.
Absolutely.
We'll talk about that.
Cool, cool. And speaking of unlimited power, you've written another piece that talks about the Supreme Court and the lack of accountability, and Justice Thomas and Justice
Alito,
who clearly believe that they don't need to really follow a code of ethics or anything. Can you talk to us about this piece that you wrote, and where you and how you feel that these justices have demonstrated that they are all powerful?
So this piece is coming out, and it's available online, and it will be out in the print edition of the Progressive magazine in the October-November issue. And the title of the piece is "A Supreme Court Accountable to No One." If you look at our judicial system, and this is something that the founders debated, and it's really been lost on many people as they recount the early ratification debates, was what kind of power will the Supreme Court have? The Supreme Court has the power of judicial review, which is the power to declare acts of Congress, acts of the executive, acts of the states unconstitutional and null and void. And so you have justices like Thomas and Alito who feel that the court really is accountable to no one, and it's kind of sloughed over into their personal behavior. These two justices in particular have accepted lavish gifts from Republican donors and failed to report them on their annual ethics disclosure documents. And they've now been exposed primarily by ProPublica, but by other publications as well. And they're not taking it all that well. So one of the remedies is that we need a code of ethics for the Supreme Court, because this is the only court in the country, state or federal, which does not have a binding code of ethics. The federal courts of appeals have the Judicial Code of Conduct, but the Supreme Court doesn't. And there have been defenses of this lack of accountability, not only by Alito, who wrote an op-ed for the Wall Street Journal over the summer, but by John Roberts. John Roberts, in one of his annual reports on the federal judiciary, I believe it's in 2011, said the Constitution created the Supreme Court and gave Congress the power to create and regulate the lower federal courts, which essentially means that we in the Supreme Court can't be touched by Congress. I don't think that was really the constitutional design. And my message to every reader is that we better demand that that not be set in stone, and that this court, like every other public institution, be held to account to the people of the United States who are really the sovereigns in this nation.
Absolutely.
Yeah, you cite that Samuel Alito op-ed. I mean, the arrogance just drips off the page that, the Constitution created the Supreme Court and nobody can touch us. How does anybody think that can be true? Nobody can touch them, I guess, except by impeachment.
Well, no Supreme Court justice. Well, I think that there was one Supreme Court justice who was impeached, but he wasn't removed. So I think that we, as a people, have demonstrated that they're not answerable to anyone, because we let it go on.
Well, in fact, it's really up to Congress, because Congress does prescribe, first of all, it passes the budget for the court. And second, it does have the power to determine the court's appellate jurisdiction, if you look at Article 3 of the Constitution. And it also did things that the Supreme Court actually likes. It created the certiorari process. That's the process by which most appeals get to the Supreme Court. And that dates back to the 1920s and even earlier than that. Prior to the Certiorari Acts, the Supreme Court had to hear federal appeals. Now it has the discretion to hear most of them, to decide what cases to hear. And so the docket of the Supreme Court on the merits has dwindled to about 70 to 80 cases a year. So when the Supreme Court likes what Congress does, it's happy to go along with what Congress regulates. When it doesn't, thumbs its nose. We can't allow that situation to remain.
But as you point out, I mean, there has been enough uncovering of corruption by ProPublica and others about people taking all these extravagant trips and money and houses bought, and that maybe things will change. I mean, it's kind of an item in the news. If we can get beyond the headlines for Donald Trump and then Kevin McCarthy and get to that, I mean, maybe change would happen.
Yes, there's this young columnist who writes for the Washington Post named Perry Bacon Jr., who has written on this topic, and he suggests that people engage in a concerted, organized campaign of shaming the Supreme Court for their blatantly partisan and undemocratic decisions. And I think that setting aside all of his faults, John Roberts is an institutionalist, and he wants people to believe that the Supreme Court is fair. So maybe, just maybe, this shaming campaign is having some effect and will continue to have some. But in the meantime, Congress has got to act. It's got to pass an ethics law for the Supreme Court to start.
Right.
And that's just the beginning.
Well, Bill Blum, thank you so much for another informative session. And we look forward to hearing from you soon, hopefully next week. You'll have some more pearls of wisdom to drop to the LA progressive community. Anything else you want to say, Dick, before we close?
No, we really appreciate this. We like getting together with you on Zoom, and we look forward to coming down to Santa Monica again and meet you on 4th Street.
Cool.
Absolutely. Always happy to be with you.
Thank you,
Okay.
Bill.
Thank you.
Bye-bye.
Thanks.